Already. A very good morning to everybody present here, respected dignitaries on the dais, distinguished faculty members, dear students, honored guests. It gives me immense pleasure to welcome all of you to JSS Law College, Mysuru for the NEETI Talks organized by the NEETI Forum and JSSLC Alumni Association as an IQAC initiator. Today's theme, privacy, technology, and surveillance, the future of human rights in the digital era, is extremely relevant in a rapidly evolving technological world, where questions of privacy and human rights are more important than ever. We are deeply honored to have with us Honorable Mr. Justice V. Ramasubramanian, Chairperson of the National Human Rights Commission, New Delhi, and former Judge of the Supreme Court of India, whose presence today adds immense value to this academic gathering. Before we begin the formal proceedings, let us invoke the blessings of the Almighty. May I now request Ms. Wangmai to kindly come forward and render the invocation.
Vinayaka ni murtike mamodati pranamam. Vinayaka ni murtike mamodati pranamam. Nivu kolunna mamanase niratamu anandadamam. Nivu kolunna mamanase niratamu anandadamam. Vinayaka mi murtike mamodati pranamam. Lakshmi Ramudu Shri Hari Kuda Tarjununi Shubhanamam Vani Brahmanu Puri Mithuda Chegurumi Gunaganam Parvati Devi Hridaya Vihari Parvati Devi Hridaya Vihari Shivakskrita Gadanata Vinayaka Mi Murtike Mamodati Pranamam Vinayaka Mi Murtike Mamodati Pranamam. Thank you.
Thank you so much, Wangmai, for that soulful invocation. It is now my privilege to invite Dr. N. Vanishri, Principal of JSS Law College, to deliver the welcome address. Ma'am, the stage is yours.
A very pleasant morning to one and all present here, seeking the blessings of His Holiness Swamiji. I would be greatly privileged to do the welcome address. It is a profound honor and privilege to extend a very heartfelt welcome to our Lordship, Honorable Mr. Justice V. Ramasubramanian, Chairperson, NHRC, New Delhi, who is with us here. Especially why we all have gathered here is to listen to a luminary of a legal fraternity whose career has been defined by impeccable integrity, profound knowledge of the law, and an unwavering commitment to the cause of justice. Sir's elevation to the highest court of the land and now the NHRC is the testament to Sir's outstanding contributions to the judiciary. His lordship is also known for his sharp legal acumen and compassionate approach towards justice delivery, which has strengthened our democratic fabric. Your lordship, your presence here today is a great source of inspiration for all of us. I extend a very warm welcome to you, your lordship. Nextly, I would deem it a great pleasure to welcome our beloved Chief Executive, Professor K. Suresh Sir, in his absentia, who has been the backbone of JSS Law College in all our academic and non-academic activities. And Sir will be joining us this evening, but he isn't here for the morning event. I extend a very warm welcome to Sir. Nextly, a very warm welcome to our Controller of Examinations, Professor P. Shivanand Bharti Sir, whose gracious presence here has given us immense support, and Dr. Jagdish A.T., the IQAC coordinator of our college, who is with us. All my dear colleagues, both teaching and non-teaching faculty members, and of course, last but not the least, our beloved students. And before I shouldn't forget with the press who are here to give a wide coverage to this event. Now, before I sign out, I would just want to give a brief or highlight about the JSS Law College Alumni Association and the NEETI Forum, which are two great forums of this college along with the other forums. So JSS Law College Alumni Association, basically our college is a very prominent legal educational institution in Karnataka, which was established in the year 1982 under the aegis of JSS Mahavidyapita, a reputed educational organization, which was founded by Jagadguru Shri Dr. Shivratri Rajendra Mahaswamiji with the objective of promoting quality education and social development. The Alumni Association of this college is a very important body that brings together our former students and maintains a lasting relationship between the college and its graduates. The association also serves as a platform for the alumni to stay connected with their alma mater, contribute to the development of the institution, and also support the academic and professional growth of our current students. So the association was established with the objective of fostering lifelong bonds amongst the past and the present students. The association also promotes interaction, networking, and collaboration among the alumni working in diverse fields such as judiciary, legal practice, academia, corporate sector, the defense forces as army officers, and the public services. It also encourages the alumni to participate in the institutional activities, share their professional experiences, and mentor the students. And along with NEETI Forum, the Alumni Association also organizes the meets, guest lectures, workshops, professional development programs, and through all these activities, they contribute their expertise to the curriculum development, internships, career guidance, and placements, thereby strengthening the academic environment of the college. Overall, the Alumni Association plays a very significant role in building a strong network of legal professionals and in promoting the values, reputation, continuous progress of this institution. So as the secretary of this association, Mr. Pranav Kumar Nair has been very actively involved in various activities which are conducted, not just the Alumni Association, but also about the NEETI Forum, which I will just take another minute to talk about the NEETI Forum. So NEETI Forum is an academic initiative again by the JSS Law College. This was created as a learning and research platform to enhance the intellectual and professional development of law students. It aims to promote deeper understanding of law, justice, and public policy by bringing students into interaction with experienced and distinguished legal professionals and scholars. The forum was inaugurated in the year 2021 by Justice Kurian Joseph, former judge of the Supreme Court of India. Its guiding idea is summarized in the tagline where experience speaks. One of the major initiatives of this forum are the NEETI talks, for which we are all assembled here this morning. It's a lecture series in which eminent jurists, judges, advocates, and public figures share their experiences and perspectives on legal issues. These programs help the students understand the practical realities of the legal profession and the functioning of the justice system. We've had His Lordship Justice Gogoi sir, Chalameshwar sir, and many other eminent personalities who have visited our college and who have shared their expertise with our students, which is of immense significance for not just the students' development, but the overall holistic development of our college. So this is a brief highlight about the two important forums which have come together to organize the NEETI talks this morning, and we're all very blessed and happy to receive His Lordship and eagerly waiting to listen to him. Thank you all. Once again, a warm welcome to one and all.
Thank you, ma'am, for those warm words of welcome and encouragement. On behalf of JSS Law College Autonomous and NEETI Forum, we wholeheartedly welcome you to the program. We are delighted that Professor Dr. Maruti is here with us today. So we welcome Dr. Maruti also to the NEETI talks. To formally introduce our guest of the day, I invite Professor Shivananda Bharti, Associate Professor and President of the JSLC Alumni Association, to kindly introduce the Honorable Speaker. So please.
Good morning to all of you. As in the capacity of President of JSS Alumni Association, it's a very immense pleasure to introduce Justice V. Ramasubramanian. Justice V. Ramasubramanian was born on June 30, 1958. He graduated in chemistry from Ramakrishna Mission Vivekananda College, Chennai, and then studied law in the prestigious Madras Law College. Before being elevated to the bench, he practiced law before a variety of judicial forums for around 23 years, including before the Madras High Court, Central and State Administrative Tribunals, City and Small Causes Court, District and State Consumer Commission. Although his areas of practice were diverse, he specialized in service matters. His Lordship was appointed as Additional Judge of the Madras High Court in 2006 and as a permanent judge on November 9, 2009. In 2016, he was transferred to the High Court of Judicature at Hyderabad for the states of Telangana and Andhra Pradesh. After the bifurcation and the creation of the separate High Court for the state of Andhra Pradesh, his Lordship was retained as a Judge of High Court of Telangana and Hyderabad. On June 22, 2019, he was sworn in as the Chief Justice of Himachal Pradesh High Court. On September 23, 2019, his Lordship was elevated to the Supreme Court of India. During his Supreme Court tenure, Justice Ramasubramanian authored 1 or 2 judgments. His judicial contributions include participation in significant cases such as the 2016 demonetization policy and the validity of circumstantial evidence in bribery cases. On December 21, 2024, his Lordship was appointed as the 9th Chairperson of National Human Rights Commission of India. Overall, his career reflects a commitment to the upholding justice across various levels of the judiciary. And once again, warm welcome to you, sir.
We have now come to the most anticipated part of today's program. It is a matter of great honor and privilege to invite Honorable Mr. Justice V. Ramasubramanian, Chairperson, NHRC, to deliver his address. Over to you.
Dr. Manish Lee, the principal of JSS Law College, Professor Shivananda Bharati, Associate Professor, Dr. Jagdish, Dr. Malati, respected faculty members, dear students. A very good morning to all of you. I did not expect this. With half the time when the speakers say good morning, it is only in very few places that the audience respond by repeating good morning, because they wait for the end of the lecture to decide whether it is actually a good morning or a bad morning. Because it is the lecture that actually determines whether you woke up for a good morning or you woke up for a bad morning. The topic that we have chosen for today's discussion is privacy, technology, and surveillance. The fate of human rights in digital era. Before I actually get into this topic, I wish to ask you something. How many of you students are very active in the social media? Can you please raise your hands? Excellent. No, some of them have raised their hands fully, some of them have raised their hands half, because they don't want others to know that they are active with the social media. My second question is, how many of you, suppose a teacher gives you an assignment to write an article on a particular topic, what do you do immediately? You type the title of the topic in Google, correct? And the Google throws a lot of results, including articles written by eminent people, non-eminent people. So what do you do immediately? What do you do? I know what you do, and your teachers know what you do, and you know what you do. You immediately read some of those articles. When we were all lawyers, we had what is called Civil Procedure Code. We used to call it CPC. The modern day CPC is cut, paste, copy, fold. That is the modern day CPC. So what all of you and perhaps all of us do, I don't consider myself an exception. I am part of you. So what all of us do is, somebody has done some research, written an article, uploaded it. We just read it, copy certain portions, make some suitable modifications so that the software that can find out piracy cannot detect what we do, correct? Very interestingly, in the English language, privacy and piracy have the same combination of alphabets there. Therefore, the result is, if you are not bothered about committing piracy, others will not bother about committing infringement of your privacy. This is the first moral of the story that all of us will have to learn. Whenever you access an internet search engine, Google, Yahoo, whatever, do you go for paid articles or free download articles? Paid articles. How many of you go to paid articles? Let me see, because I want to know how many people are rich here. How many people go to the paid articles? How many people go to the free articles, free download? Almost all of us. But do you know what is happening? An information technologist told me very interestingly that the first lesson you must learn while dealing with information technology is that if somebody is giving you a product or service free of cost, it means he is offering you as a product or service to somebody else for a cost. How does he do that? The moment you access a free download, you will find cookies appearing. Most of us belonging to my generation thought that, oh, along with the article, they are also offering some biscuits. Cookies, we thought they are all biscuits. And it says, accept cookies. We say yes. When somebody is offering cookies, do we have coffee also along with cookies? We say yes. So all the personal data that you have, you are actually providing access to those people to your personal data. That is the cost that you pay for a free download. This many people don't realize. All of us start blaming, oh, the state is keeping a surveillance. Somebody is stealing my data. But what are you doing? You are prepared to steal somebody else's data. Those people waiting as predators, they prey on you, they co-opt you, they say we are all big thieves. We are waiting for small thieves to come into our net. We are all of us are small thieves. We look for some small petty things. Then we become co-opted into a huge gang of thieves. That is how the first level of infringement of privacy takes place in the social media. When I was a judge of the Hyderabad High Court, a lot of girls are here, you must know what you do, what you should not do. When I was a judge of the Hyderabad High Court, the Cyberabad Police Commissioner, who was in charge of cyber crimes, he narrated to me a very shocking case. One day, a student of an engineering college staying in a hostel gave and wanted to lodge a complaint. She did not want the complaint to be in writing. She said, sir, some unknown person is sending me emails threatening to post my nude pictures online, demanding money. At first, I ignored the threat because I had never taken selfies in a nude way. I don't have friends online to whom I send these photographs. If I have not taken photographs, if I have not sent any photograph to any friend, how is it that somebody can blackmail me? So I ignored. When I started ignoring, the blackmailer sent me a sample copy of my photograph. It was not a morphed image. So I am terrified. That is why I have come to you. The commissioner, cybercrime commissioner, investigated her. It was absolutely clear that she had no friends, unknown friends or known friends to whom she had shared the photographs. Then how could this happen? She had already transferred 50,000 rupees to the blackmailer. He was demanding more. So the first trace was that this police commissioner went to the bank to find out the person into whose account the money had been transferred. But unfortunately, it was a pseudonymous account. By duping the bank without providing proper KYC. Do you know what is KYC? Know your customer details. Somebody had opened an account, they had taken away this 50,000 rupees. The address was fake, the person was fake. Therefore, the police hit a roadblock. They could not proceed further. Then the only other alternative open to the police commissioner was to take a series of procedural steps to find out the IP address from which the email was sent. Do you know there is an IP address? It's all in numbers. It is impossible for you and me as a common man to know the IP address of somebody. All of us, without knowing what is what, we are carried away by a huge campaign that privacy, personal data, protection, IP address should not be revealed to anybody. Therefore, when you become the victim, you can't get the IP address because you stand out with a placard, protect my privacy. It is protected. So the police commissioner took a lot of series of steps, ultimately found out the IP address. The crime happened in Hyderabad. The IP address of the person was traced to a village near Cuttack in Orissa. Fortunately, the police commissioner went there, caught hold of the person from whose IP address the mail had generated. He seized the laptop. What he found, the methodology adopted by the criminal was very interesting. What this man was doing was, I'll ask you, how many of you are interested in music, light music, cinema music? How many of you download the music albums which are available free of cost in the internet? Oh, only 3 people download. I don't believe that. I know many of you download music. Don't say I don't download. And I know many of you don't pay. You know what this young man was doing? He was uploading popular music songs in the YouTube. But while doing so, he was injecting a virus into those albums. The virus was capable, the moment you download the video in your laptop, you are downloading not only the song but also the virus. That virus is capable of switching on your camera once you operate the system. So what this young man was doing was uploading music albums, just making an attempt. 1,000 people download. One of them may happen to be a victim like this girl. She had downloaded video. One day morning, she was working in the system. She was in a hurry to leave. She did not shut down the system. He went to the washroom, took a bath, came back to the room. She changed her clothes. That was captured by the camera in the video that she had downloaded and it was sent to you. Now, how has this girl become the victim of privacy? She had become a victim of privacy because of a very small, all right, let me hear a good song. It is available free of cost. It was not available free of cost. Therefore, learn to suspect whatever is made free of cost to you, because it comes with a hidden cost which you do not know. That is why the law of privacy as it was before 1993. Why 1993 is important? It was only in 1993 that Tim Berners-Lee made available what you now call as WWW, World Wide Web. The expansion of the word WWW is World Wide Web. They invented, Tim Berners-Lee invented, along with another person, in 1991, WWW, and he made it available. Of course, he did not, there was no hidden cost. He made it available to the universe in 1993. So what you understood as privacy before 1993 is completely different from the way technology has changed our right to privacy. That is why in 2000, a company by name Sun Microsystems, an American company, when the computer was created, there were languages. Java was one of the languages used those days. A company which created this Java programming language was called Sun Microsystems. It was an American company whose CEO by name Scott McLean, he made a very interesting statement in the year 2000. You know what he said in 2000? Privacy is dead. Deal with it. 2000 he said. Take a clue from what he said. Brock Meeks, an award-winning investigative journalist and MSNBC.com's chief correspondent, wrote an article titled, "Is Privacy Possible in the Digital Age?" The title of the article was, "Is Privacy Possible in the Digital Age?" It was published on 8th December 2000. This is what he said, I quote, "Privacy in the digital age may not be as dead and buried as McNeely believes, but it is certainly on life support. Our unbridled love affair with all things technological has an evil twin, a seemingly unstoppable encroachment on our personal privacy. The same streaming video technology that allows our grandma and grandpa to chat with grandchildren is being used to spy on employees in the workplace or capture unsuspecting lovers stealing a kiss." This is what Brock Meeks said. So let us have a look at how technology impacted privacy and what privacy was before 1993. I don't know how many of you are aware of the fact that the history of evolution of the law of privacy began exactly 400 years ago. It was in 1604, exactly 422 years ago, that Sir Edmund Cook made a very famous statement in Peter Semine versus Richard Gresham. What he said in that case was, "A man's house is his castle and fortress, as well as his defense against injury and violence, as per his repose." This statement was made by him in the context of the sheriff of the town searching for movable items in his house, for attaching those movable items, for enforcing a money decree passed against somebody else. There was a money decree against X. That X had kept certain valuable movable items in Y's house. For attaching those properties and bringing them to sale for realization of the money decree, the sheriff searched the other person's house. Whether such a search was valid or not was the question involved in 1604. Look at how the infringement of privacy happened in the real physical world with physical objects that we were able to see. from which in the past over 400 years how it has transitioned. This court in 1604 resulted in what we now known as Petition of Rights of 1628. This 1628, that is another watershed in the movement of in the history of development of human rights. The reason why Petition of Rights 1628 came into existence was that the king had power in England, not in India. In England, the king had the power to house troops in private residences. Suppose you own a house in Mysuru. Imagine the king of Mysuru had the liberty to send his troops who will stay in your house, have coffee, tea, meals, etc. That was the power that the English crown had. Then when the world, the England woke up to the reality of privacy, how a man's house is his castle, then Petition of Human Rights, the Petition of Rights 1628 came to be passed. And therefore, what actually Edward Cook said was amplified by Sir William Pitt when he made a very famous statement. William Pitt was the Prime Minister of Great Britain those days. He said, I quote, "The poorest man in his cottage bid defiance to all the forces of the crown. His cottage may be frail, his roof may shake, the wind may blow through it, the storm may enter, the rain may enter his cottage, but the King of England cannot." That is how he summarized, William Pitt summarized the right to privacy in 1628. After about 300 years, first time an actual conception of the law of privacy developed when an article appeared in the Harvard Law Review. In the Harvard Law Review, in its edition dated 15th December 1890, an article appeared. The title of the article was Right to Privacy. In fact, privacy was not a term used during Edward Cook's time and William Pitt's time. First time right to privacy, the coining of the term happened in 1890 in this Harvard Law Review article. It was authored by Samuel Warren and Louis Brandeis, both alumni of the Harvard Law School. Brandeis later became a judge of the United States Supreme Court. This is considered to be one of the most influential essays in the history of development in the law of privacy. From that stage, the law continued to develop stage by stage. But very interestingly, whenever there was an invention of technology, first the predators made wrongful use of technology. Then the prey made complaints. Then the police tapped the technology. Thereafter, the court said, are you entitled to do it? This is how the tracking system happened. I can give you one example. In one of the earliest cases to come up before the US Supreme Court, called Homestead versus United States, Homestead, a person, was prosecuted for violating the National Prohibition Act by unlawfully possessing, transporting, and selling alcohol those days. Now, probably if you don't have alcohol, they will prosecute you. So the conversations that Homestead had with his employees and business associates over a period of time on telephone were tape recorded by the police. Whenever Homestead talked to people, how many barrels of liquor you are going to supply, these telephone conversations, telephone was an advancement of technology those days. Whenever he had these conversations, the police tape recorded the conversations without his knowledge. And through wire tapes attached to the telephone. Under the 4th Amendment to the Constitution, US citizens were guaranteed a right against unreasonable search and seizures. Therefore, the question that arose was whether wire taping my telephone cable, listening to the conversation, tape recording it, did it amount to unlawful search and seizure? Was the question that arose in Homestead versus United States. But what the United States Supreme Court did was wire tapes attached to the telephone cable in a public street did not tantamount to unlawful search and seizure. If only the police do it at your home, it will become an unlawful search and seizure. Therefore, the court said this does not tantamount to violation of your constitutional Fourth Amendment right. But this decision came to be overruled 40 years later in Cards versus United States. Cards versus United States, a very interesting decision where Charles Cards was a gambler. He was suspected of using a public telephone booth to transmit illegal wagers, betting upon contracts. The FBI, Federal Bureau of Investigation, recorded his conversations via an electronic eavesdropping device attached to the exterior of a public telephone booth. On the basis of these recordings, he was convicted. But the Supreme Court overturned this decision, saying, though public telephone booth is a public space, the moment a man enters into the public booth and shuts the door and puts the coin in the public booth, he has shut even the police out of his privacy. Therefore, what happened to Homestead was overturned in Cards. So the law continued to develop state by state. Whenever there was a technological invention, when technological invention was used by a wrongdoer, when the police tapped the technological device to prove the wrongdoing, the courts tended to protect the right to privacy at the cost of letting off the criminal. Therefore, privacy is actually a double-edged weapon. I always used to think that the way the law developed in the Western world, it is little different from the law that we have always had in our tradition. The law that we have always had was to find out the truth. But unfortunately, the jurisprudence developed in the Western world was focused more upon how you found out the truth and not on whether you found out the truth. The law that developed in England and US focused more upon not the contents of what you found out, whether true or false, whether you adopted fair means of finding out or not. Therefore, it became a fight between fairness of procedure and truth. Whereas in our country, we placed more focus traditionally upon truth than upon fairness. What is right or wrong, I am not going to dwell upon that. Then what happened after these developments of law? As I said, internet developed. When internet developed, social media developed. Social media virtually became a trap for all of us because it is so attractive, you cannot live without it. When you go out of station, whether you forget to take your clothes or not, you cannot today forget to take your smartphone. You cannot today forget to take the mobile charger. You feel as if you are completely without clothes if you are without a telephone. It is through these instruments that what happens is technology has started intervening. So who are the perpetrators of the right to privacy? Unfortunately, the entire world focuses on the surveillance made or sought to be made by the state, without realizing that persons who infringe your right to privacy fall under 4 categories. What are those 4 categories? Government and the law enforcement agencies. That is the first category. This came to light. The world became aware of this in the year 2013 when Edward Snowden flew out of America, went to Hong Kong, and made a set of disclosures that the United States National Security Agency had a scheme called a program called PRISM, through which they were conducting surveillance on the personal data of many people. So Edward Snowden became a fugitive in several countries. Ultimately, he was extradited, he was imprisoned, etc. So 2013, the world became aware of how the state governments use. The first category of persons who invade privacy are the government and the law enforcement agencies. Second category of persons who infringe your right are the service providers. Internet service providers actually provide many services and products free of cost because your personal data is being exchanged with them. That is the hidden cost. I tell you one example. Suppose today you want to go to a restaurant where you get excellent North Indian food. You type North Indian restaurant nearby. Thereafter, every day you get advertisements of such North Indian outlets. How do you get it? Because once you type, that is recorded, transmitted, and the service providers make huge money out of the advertisements that they provide for those outlets. So the second category of persons who there is no check. People demand a law where they can be protected against state surveillance. But do you really seek a law where you are protected by internet service providers? Second category of persons. Then the third category of providers, the persons who infringe, are the information providers. For instance, I am in possession of certain information. I am prepared to share it with you. I upload, but I ask for your information, cookies, choices. Reject all. Reject all is an option given only by few. Otherwise, they say restrict. Either you throw open all your data or restrict. Reject all is not an option given to many people. So information providers happen to be the third category of people who infringe. Then the last category of persons are the hackers. While all of us focus on the first and last category of persons, we want a law in place to protect us from state surveillance. We want a law in place to protect us against hackers who today indulge in digital arrest scams, etc. We are not concerned about information providers. We are not concerned about service providers. Therefore, what we will do is a larger question that I think all of us need to ponder. Today, without your having any social media account, your information cannot be collected by anybody, except in cases where you have an Aadhaar card. You want a scheme. Aadhaar card is not compulsory. But unfortunately, for many of the schemes to apply, for many places, Aadhaar card is insisted. But there are provisions in place where it can be controlled. But if you do not have a social media account, there is no way that any of the categories of these persons can really conduct a surveillance on you. So what is important today is, instead of focusing on how to protect my data, this protection should start from the individual concern. Do we protect our data first? If I don't care about my data, suppose you have a house in which you have a huge jewelry store. You say, no, I live in a good society. I don't keep my door shut. I don't lock my door. I come out in the I go out of my house in the morning. I come back late in the evening. It is the state's responsibility to protect my property inside the house. I will leave the house open. People who have social media account and post their personal data are like people who keep their houses open and want a law to catch hold of the thieves. So with these few words, I take this opportunity to, because we have a question and answer session, so I don't want to exhaust all of it. Thank you very much.
Thank you very much, Your Lordship, for that enlightening and thought-provoking address. Your insights on privacy, technology, and human rights have given us much to reflect upon. Well, as a token of our gratitude and respect, we would now like to felicitate our distinguished guest. I now request the dignitaries on the dais to kindly felicitate Honorable Justice Ramasubramanian. I request His Honorable Lordship to kindly accept the felicitation. Thank you once again to your Honorable Lordship for gracing this occasion. To express the gratitude to everyone who contributed to the success of this session, I invite Dr. Jagdish Shetty, Assistant Professor and IQAC Coordinator of JSS Law College, to deliver the vote of thanks. Over to you, sir.
Respected Chief Guest, dignitaries on the dais, respected teachers and dear participants. On behalf of the organizing committee, it is my great privilege to propose this vote of thanks for this wonderful occasion. First and foremost, I extend our heartfelt gratitude to our chief guest for gracing this event with your esteemed presence and for inspiring words shared with us today. Your guidance and encouragement truly motivate us to strive for excellence. Your Lordship, it was not only a good morning, it was a fantastic morning for the students of JSS Law College. Thank you. I also express my sincere thanks to our Chief Executive Professor K. Suresh, who has been the constant support and backbone of all our activities in his absence here. I thank our Principal, Dr. N. Vanishree, Madam, for her presence here. Thank you, Madam. Also, I would like to thank Professor P. Shivanand Bharti, our Controller of Examination, and the Chairperson, President of the JSS Alumni Association. Thank you, sir. My special thanks goes to the organizers, volunteers, and team members whose dedication, hard work, and coordination made this event a grand success. Also, I would like to appreciate all the participants whose enthusiasm and talent made this program lively and memorable. Last but not the least, I thank Mr. Pranav Kumar Nayak, the coordinator of NEETI Talks and the host of this program. With this words of gratitude, I once again thank everyone who contributed directly or indirectly to the success of this event. Thank you all.
Thank you so much, sir. May I now request the audience to kindly rise and please stand still till the dignitaries leave.
No, I'll just keep it here. Yeah. Or shall I remove the laptop? Shall I take it out? No, I don't want the laptop. This is absolute. Paper. Yeah, one.
Good morning, sir.
Morning.
I welcome you all to the second session of today's event, that is the panel discussion, where Justice Sir would be discussing with us regarding our questions. On behalf of Justice Law College, Mysuru, it's my privilege to welcome you to our NEETI talk, sir, on the topic privacy, technology and surveillance, the future of human rights in digital era. I am Janvi Suresh.
And I am Abhijit Kaundinya, sir.
Thank you.
We are truly grateful to have you on our campus. With your permission, we would like to begin with the proceedings.
Your Lordship, the first question is, today, biometrics such as Aadhaar authentication, facial recognition have become a routine part of governance. We share our personal sensitive information in everyday transactions. How can we make sure that these technologies are used in proportionate and does not undermine the fundamental right of privacy?
Actually, unfortunately, we have all been trained to think that it is only the information that we share while getting an Aadhaar card, etc., that is being shared by the government and others, and then our privacy is increased. But that is not the whole truth. As I said in my talk today morning, government and law agencies are only one out of the four categories of people who need their privacy. Government can be made law-abiding because they create the law, codes are there. But how do you control the information service? And how do you control the information providers? How do you control the service providers? How do you deal with the hackers? That poses greater challenge than this biometrics and Aadhaar, etc. If you really look at Aadhaar, the kind of information that they take from you are only bare minimum. But with what you do with Aadhaar, where you share information with Aadhaar, there it acquires more and more information. Therefore, it is not exactly, that is why 2023, this Digital Personal Data Protection Act has come. There are certain areas in which people have problems about that. It is the subject matter of challenge, etc. See, you must understand the history and evolution of law. Law has always trailed behind criminals. Somebody commits a crime, then the lawmakers wake up and create a law. The moment you create a law, the criminals find the loopholes in the law. Then the lawmakers plug the holes in the law. So it is always a wild goose chase where persons who break the law go in front. Persons who enforce the law trail behind it. That's the point.
Thank you so much, sir. So the next question. In one of the recent interviews, you laid down the classification about the 4 generations of rights of place. Since we are discussing the future of human rights today, so what according to you would be that 5th generation of right? What would that be, sir?
I don't think it is easy to predict what will be the 5th generation of rights. For the benefit of the students assembled here, let me tell you what happened was, traditionally, it was only civil and political rights, which started at first. The discourse did not start it. Discourse was first about civil and political rights. The protection against the state, protection against sovereign power, participation in governance, etc. Then, social, economic, and cultural rights emerged. For instance, Universal Declaration of Human Rights of 1948, it encompassed within itself
two categories of rights. One, civil and political rights. Next, social, cultural, and economic rights. Then, after the 1970s, the world started realizing that as communities, as societies, we have certain collective rights. Imagine civil and political rights, right to vote, right to equality, right to liberty, social, cultural, economic rights, my right to fame, my right to preserve my culture. These are individualistic. But after 1970, when the air became impure, when water became impure, society started realizing that there is a third generation of rights, namely the collective rights of communities and societies. To have pure water, to preserve the environment, to preserve air, it was not individualistic. Suppose the air quality index in Mysuru is about 20-30. I come from Delhi where the air quality index is 400 during highly polluting days. So to have this problem set right is the right of the people living in Delhi as a whole, not individualistic. So environmental rights became the third generation rights and they were the collective rights of community societies. This development came after 1970s. Then, after 1990s, when the World Wide Web (WWW) became, available, technology advanced, the new genre of rights, namely the right to privacy. Right to privacy arose in a different context, with the whole dimension being completely different after this. Right to be forgotten. All the genre of rights came after advancement of science and technology. Therefore, fourth generation of rights arose after advancement of science and technology. While they were dealing with the first generation rights, civil and political, while they were dealing with second generation of rights, social, economic, and cultural rights. They never contemplated that we will move on to the third generation. We moved on. When they were dealing with collective rights of societies, third generation of rights, environment rights, we never contemplated the sudden spark in information technology, science and technology, which will give rise to new genre of rights. So fourth generation rights came. I don't know fifth generation of rights, what will be in store for humankind. It depends upon any innovation that we make.
Thank you, sir. Today, most of us live a significant part of our lives online, sir. So,
I think the volume is very high. The volume will not be important. They'll have to reduce the volume to some extent. I am able to keep it away from me, therefore, I am making it I am able to adjust the technology.
today, most of us live a significant part of our lives online, sir. So, how do we bring in digital literacy and digital hygiene among the masses to ensure one's rights are not being violated in the digital domain?
Actually, there is a very interesting statement. Charity begins at home. Therefore, digital literacy and digital hygiene should first begin from us. Are we taking care of our digital hygiene? Are we digitally fully literate? I will tell you a shocking instance, which I had an occasion to come across when I was in Bangalore. The extent to which we have started misusing technology. Every one of us is guilty of misusing technology. People take selfies. Then we are interested in adventure. In the railway track, when the speeding train comes, we want to take the selfie because we want it to go viral. How many people should look at it? so that we become several YouTubers, etc. Why do we do that? Do we really have that literacy to maintain control over ourselves? Then why do you talk about how to enforce the digital hygiene among the masses? First, let us implement it with us. There was an interesting case in Hyderabad. An actor, he was not even an actor of the current generation, he was an actor of previous generation. He died in a very tragic road traffic accident. When his body was brought to the hospital and it was lying there for postmortem, some of the nurses, both male and female, took selfies with the dead body and posted it online. They are all educated people. Where do we go? So digital literacy and digital hygiene should first start from us. We have to maintain certain standards. First, protection and ethical standards. If we do not see in the digital world, one thing that has happened in the digital world is they have converted everybody into a thief. They have converted everybody into a beggar looking for freebies online. There is I told you in the morning, there is a mood court competition. You just type something. All of us are prepared to steal somebody else's work. So it is not merely about digital literacy and digital hygiene, it is about digital ethics. Digital ethics should be maintained by all of us. Only then hygiene and literacy will spread.
Thank you, sir. So the next question is pertaining to a very recent case. Very recently, the sitting Supreme Court judge from Sri Lanka has approached the Honorable High Court of Karnataka, sir, invoking his right to be forgotten and seeking for online content depicting him to be taken down from the Google search results. So with this in mind, how does this highlight the intersection between digital footprint as well as human dignity in the internet age?
This new generation of this right to be forgotten, I think if I can switch off this fan, then it will. All of you are able to hear me properly? No. Hello. The volume reduce it a little bit. I don't want, because fan actually amplifies the. You have to know how the mic works, how the fan interferes with your mic, all that. Actually, what happens is. I forgot your question.
So very recently, a
Right to be forgotten, yes. The earliest case where the European Court of Human Rights developed this right to be forgotten was in the case of a person versus Spain. I'm not getting the name of that. I can tell you the name of this thing. So versus Spain. What he found was that this man was prosecuted sometime about 20 years ago for some offense and he was acquitted. But whenever somebody accessed the Google, typed his name, all the information that displayed about this person included an information about his prosecution for an offense and his subsequent acquittal. So he went to the European Court of Human Rights on the basis of Article 8, where my private life has got to be secured. When he went there, European Court of Human Rights made a distinction between digital footprint and the physical footprint. The court thought, all right, because digitally it is capable of being erased, you want that information to be erased. But suppose that information had been published In the Times of India newspaper, the Hindu newspaper, the Indian Express newspaper 20 years ago, the newspaper is preserved in the archives. How do you get it erased? You cannot ask for destruction of the whole copies, correct? So the right to be forgotten is again an area where the courts are adopting a very cautious approach for this reason. I will give you one example, which may really be of some interest. Suppose, all of you are youngsters. After 5 years, 10 years, you want to get married. And you have not already picked up your partner while in college. You look for a partner. Somebody's profile comes to you. How do you check up the credentials of the person? You go to the Google, find out LinkedIn, Facebook, X, all that you type out. And suppose that person has exercised his right to be forgotten and he was actually a criminal. Where will you land up? Now, how many of you, in this example, how many of you support the right to be forgotten? How many of you, because I wanted to know if somebody supported the right to be forgotten here, then I am sure that he would have left a digital footprint of something wrong he had done. Fortunately, you did not, none of you raised any hands there. Medical history. He need not even be a criminal. In fact, the first case where it is almost like right to be forgotten in the case of Mr. X versus hospital. Indian Supreme Court had the occasion to decide. A person was found to have suffered from HIV because of transmission of HIV infected blood. In the case of matrimonial alliance, when they accessed the medical records, when they went to the hospital, this information was spread out. Therefore, compensation was claimed in the hospital. Now, in the context of matrimonial alliance, do you support right to be forgotten? And in the context of employment, suppose I want to employ somebody on my roles. I want to see if he has had criminal antecedents. Do you suppose you want it, like, let us take, for example, you want a very good house in Mysuru. You want to employ a watchman. Would you like to check his antecedents? Would you like to check whether he had criminal records or not? And suppose he had a right to be forgotten. You have to forget your property. You must also have a corresponding right to forget about your property if his right to be forgotten has got to be incident. Therefore, every right has got its twin brother or twin sister where we have to tread very carefully on certain paths. Yes, there are certain areas where I am entitled. Society, one thing you must know. Forgetfulness is ingrained in the society. It is always said that public memory is very short. Persons against whom you make huge allegations, you vilify him yesterday, today they become heroes. Online, what you do becomes significant because we talk of many things theoretically, academically, without applying on ground.
Yes, sir. Next question. With increasing concerns about hate speech on online platforms, how should a balance be struck between one's human dignity and the freedom of speech and expression?
See, in America, there are no restrictions to speech. In India, the constitution which guarantees free speech also provides certain restrictions. Freedom of speech is not absolute in India. In fact, in the context of Kaushal Kishore, which I had an occasion to author as part of the constitution bench, the question that arose was, are the safeguards already in place for restricting free speech sufficient, or should we have more safeguards, was the question. Because Kaushal Kishore's case arose out of an incident where a girl was allegedly raped and murdered. When there was a big hue and cry, a minister of the state government made a statement that this never happened, is completely false. So ultimately the court came down upon him because even before completion of investigation, such statements by responsible persons in office should not have been made. So in that context, the matter was referred to the constitution bench as to whether the right to free speech can have an upper hand over the liberty of other people, right to dignity of other people, whether the right to free speech can extend to such a level that you can get away with whatever you say, and whether it requires more safeguards. It requires many more parameters for restriction of the question, while rejecting the contention that there should be more restrictions. The Supreme Court said hate speech is something which we are not able to actually deal with. I will tell you what. I had an occasion to write an article for the Hindu about 12 years ago when I was sitting in the Madras High Court. The title I gave was Hate-Free Speech versus Free Hate Speech. Today, hate-free speech has become free hate speech. I can offend the sentiments. If I offend the sentiments of other people, it falls under the category of free speech. If they offend my sentiments, it falls under the category of hate speech. This is the double standards that our society has come to adopt now. So where do we draw a line? I can tell you a real life example. There is a political party in the state of Tamil Nadu which every year holds an annual meet to celebrate the birthday, but without naming it. They will not say the purpose, but the actual purpose of holding that annual meet is to celebrate the birthday of a Sri Lankan fighter. Every year the court used to reject the application, the government used to reject the application for permission to hold the meeting. They used to come to court. When they came to court before me, I asked the lawyer appearing for the political party, now you want to hold the annual event to celebrate somebody whom according to you is a great leader. So the police is refusing permission and you are attacking the refusal of the police on the ground that my freedom of speech is infringed, correct? He said yes. Then I asked him, I will ask you one question. In Kerala, somebody has produced a movie called Damn 999. That movie was about the dispute between Tamil Nadu and Kerala on sharing of the Mullai Periyar dam water. I asked this lawyer, what is the stand of your political party in this case? He said, my lord, we want that film to be banned because it is hurting the sentiments of Tamil people. Then I asked him, if the government says no to you to hold a political meeting or celebrating somebody's birthday, it is infringement of your right to speech. When another person produces a movie affecting your sentiments, it falls under hate speech. What is this double standard? So today we live in a society where we are adopting double standards. That is why neither the government nor the court is able to tackle this problem.
Thank you, sir. So moving on to the next question, we'll be deviating a bit from the theme of the day, sir. So in today's volatile geopolitical climate, sir, has the strategic and political interest outweighed human dignity as well as civilian rights, sir?
Of course it does. See, the human dignity, the right to dignity now encompasses within itself a whole bouquet of rights. First, people should have adequate means of livelihood, right to food, right to water, right to clean environment. Without all of this, there is no right to dignity. In geopolitics, what has happened is every country wants to pitch the right of their own people to a decent standard of living, even if it is at the cost of the population, people of other country. And every people of every country is okay with the idea. There is no country which is an exception. Every country thinks that my country first, my countrymen first. Can you really say it is wrong? You are not able to say it is wrong. But at the geopolitical level, it is actually wrong because what happened? Industrialization. If you look at the history, see, as students of law, I would urge you to do one thing. If there is a law, study the history of the law and also the philosophy of the law. Unless you study the history of the law and the philosophy of the law, you will never understand why the law is what it is. Now, at the geopolitical level, it was okay for developed countries to exploit developing countries. When they said, how do you do it? They said they are all living without 1 square meal a day. I am pumping money. I am providing food for them. They survive because of us. This is the thought process that developed in developed nations. So it was okay for them to exploit these people on the ground that I am providing. By doing this, I am providing food for you. This is how human dignity became a casualty. You became developing countries were treated as beggars and as non-entities by developing countries. Some countries had no choice. Some countries have a choice. When they exercise the choice, friction arises. Oh, till yesterday this man was, today he is standing up. This is what is happening at the geopolitical level.
Thank you, sir. The next question is about climate change. There are many skeptics among us who do not believe in climate change. Their actions go largely unnoticed, but yet they are a catalyst to the environmental degradation. So, Lordship, what does the current international instruments and the domestic laws impose adequate obligations on this group for them to protect the environment?
As I said, protection of environment, the whole world woke up to the reality only of 1970s. So first we had the Air Prevention and Act. Then we had this Water Act. Then we had the Environment Act. Then National Green Tribunal was established. Then environment impact assessment became necessary for every project. Unfortunately, the theoreticians, academics developed what is called the theory of sustainable development. Every country wants to be a developed country. If you want, see, it is a cycle into which all of us got caught. You want to be a developed country. If you want to be a developed country, you must exploit your resources, natural resources. If you have to exploit your natural resources, you must have money. If you have to have money, you must invite investments. If you invite investments, they will dictate terms to you. When they dictate terms to you, you have to compromise on environmental degradation because natural resources cannot be exploited without environmental degradation. For instance, I was chief justice at Madhya Pradesh for 3 months. To develop that state, under the guise of developing that state, 4 laning of highways they started making 4 laning of highways. In a beautiful hill station, if there are 4 laning of the highway, then the soil becomes loose, the hill becomes fragile, the ecology becomes fragile. When I took my farewell, I told my friends in Shimla that if you have lot of development, be rest assured that after 30 years, Shimla will be in the plains adjoining Chandigarh and not in the hills. So sustainable development is a mantra through which environment is, sought to be protected but destroyed. We need development. If we need development, we have to exploit our resources. If you exploit resources, you have to allow environmental degradation. This is a compromise. They are plant trees. Take for instance, there are systems in place where deforestation takes place. For every axed tree, they say you plant 100 trees. How many years these plants will take to grow into a tree? What you destroy is, a cow which can milk today under the guise that tomorrow a calf will be born, without knowing whether it will be a male calf or a female calf, whether it will survive, etc. But there is a dilemma. Whether to have development or not to have development is something which we can't really, there is no choice. I always think Mahatma Gandhi solution. Of course, we will not be sitting here, there will be no mic. Mahatma Gandhi developed the theory of village economics. You must read that the J.C. Kumarappa, Gandhi and Economics by J.C. Kumarappa. I request all of you to read. Gandhi conceived every village as a self-sustained country where they will not depend upon other people. There will be agriculture, there will be artisans, there will be pottery. You will have food, you will have clothes, but you will not have modern equipments. But there the environment would have been preserved for generations to come. Now it is not possible to reverse the whole thing back.
Thank you, sir. So the next question. Very recently in the modern world, there have been a lot of incidents with man-animal conflict, and also a lot of debate surrounding ecocentric approach and anthropocentric approach. So from the perspective of the chairperson of NHRC, how can a balance be achieved between the rights of man and the rights of animals, and so as to ensure both are protected?
See, this again is a very difficult problem. I will tell you what happened in the case of Jallikattu. All animal lovers opposed the game of taming of the bull, Jallikattu in Tamil Nadu. The amount of opposition that it generated through social media. People were invited in Marina Beach. Continuous candlelight vigils were carried out by young people to the old people for days together, demanding that Jallikattu should be preserved because it is a cultural identity of the Tamils. What do you do? Animal lovers became actually villains. Culture is a name, language is a name, culture is a name, religion is a name, which you cannot oppose today. If somebody says it is my culture, you are subdued. Your voice is submerged. In fact, this conflict is not only peculiar to India, it is universal. See, if you read intellectual property right in the context of this, you will find there is an organization called PETA. See, PETA is people for ethical treatment of animals. PETA, people for ethical treatment of animals. In America, somebody registered another domain name with the same PETA. When they challenged, you know what they said? My PETA is not people for ethical treatment of animals. My PETA is people for eating tasty animals. People for eating tasty animals, PETA. So how do you now deal with this situation? Man-animal conflict, deforestation. We encroach upon the land occupied by animals. Therefore, they are invited to our land. They don't come to our land. They come to the land that was once owned by them. But unless we deforest, there is no development. If there is no development, 1.45 billion people cannot be fed. So animals take a secondary seat. Then there is a big hue and cry. We don't understand that we all eat food because to some extent the cycle is preserved, the biological cycle. There is a very interesting portion in the Tamil version of the Ramayana, where when Rama wanted to shoot Brahmastra against Varuna, the king of the seas, he comes and surrenders. Then Rama asks him, what is the goal for my arrow? He says, there is a particular island in which people are eating lot and lot. At this rate, they will consume the whole food available in the world. So kill them, because nobody should consume more than what they deserve. This is the biological cycle, how it is maintained. Unless there are species, man cannot survive. If all species, all animals are destroyed, man can definitely not survive. It requires some kind of ethical principles getting imbibed into our DNA. Not alone can solve this problem.
Lordship, the next question is about predictive policing, that is using AI and mass data analytics to predict who will do a crime. This is efficient administered in a point of administration, but isn't it a discriminatory practice?
Who would commit a crime? I don't think, nobody can predict who would commit a crime. But I can predict, I can tell you, if the proper environment is created and an assurance is given that you will not be found out, every one of us will commit a crime. Look at yourself in the mirror. If a proper environment is created, if there is an assurance that you will not be caught, every one of us will commit a crime. I ask you, are you sure that you are not already committing a crime? Wherever you violate a law, you are committing a crime. Simple example. You want to go to a particular place, you have to reach in 10 minutes. There is no policeman. There is a red signal. How many of you wait for the signal to come to green? You wait. Very good. So you will never commit a crime of this nature. I will take up other examples. So AI cannot predict, but AI can predict something else. I don't know. Right now, I may not have it in mind. See, there is something called a formula was developed by scientists to find out recidivistic tendencies in people who commit crimes. Suppose on the question of sentencing, somebody developed a very interesting formula. After a person is convicted of a crime, on the question of sentencing, some judges applied this formula to find out whether this man has recidivism is a tendency to commit the crime again and again. That is called recidivism in law. To see if a person has got recidivistic tendencies, they applied this formula. Let me check up if I have this in my. This is how you have to use the technology.
Yes, I got it. See, somebody developed a formula. S is equal to A within bracket minus W plus A first within bracket minus W plus H violence W plus BE DU W plus HNC W. Do you understand anything? I know all of you would say, sir, these are all the scientific formulas. We wanted to avoid science and came to law. Correct? All of you are run up in law because you hated science. Correct? Science and mathematics. So this formula, in February 2013, a person by name Eric Loomis was found in a place called La Crosse, Wisconsin, United States, driving a car that had been used in a shooting incident. Not film shooting, real, shooting from a pistol. He was arrested. He pleaded guilty to the charge of attempting to flee the traffic officer. While determining the sentence, how many months of imprisonment should be imposed, the judge looked at his criminal record as well as a score assigned by a tool, online tool called Compass, COMPAS. Compass classified Loomis as having high risk of committing the offense once again. So, the judge sentenced Loomis to 6 years of imprisonment. When he appealed to the Wisconsin State Supreme Court rejected the appeal on the ground that it is based upon a scientific formula. Scientific formula is what, we all tend to apply. So how do you probably such scientific formulas may predict whether there is a tendency in a human being to commit an offense again. But AI cannot certainly predict whether somebody is prone to commit an offense because when laws were enacted, one of the earliest smritis of this country say that when all people were good, there was no necessity for laws. Only when people started doing bad things, law had to be brought into force. That is the development of science and technology also.
As we come to the end of discussion, on a lighter note, I would like to ask, we students over here are very curious to know what was the driving factor which brought you into the legal field and subsequently the judiciary, sir. So, considering that most of us over here are first generation lawyers, what is it that you would like to give us from your experience and anecdotes from your life that will help us in guiding and getting a perspective to our lives, sir?
See, when I was given farewell in the Supreme Court, along with me, two other judges also had a farewell. Justice K.M. Joseph, Justice Ajay Rastogi, and myself, all the three of us had a farewell on the same day in the Supreme Court. So when the speakers talked about all the retiring judges, everybody said Justice K.M. Joseph's father was a retired judge of the Supreme Court, Justice K.K. Matthew, great man. Then when they said Ajay Rastogi's father was a great civil lawyer in Rajasthan, when it came to me, they said he is a first generation lawyer because there is nothing to do. So when I went to speak, when I went to give a reply to my farewell, I began my speech by saying, I have the unique advantage of being the first generation lawyer. That's how I began. I said that Justice K.M. Joseph is the son of a very illustrious former Supreme Court judge. Justice K.M. Joseph has the disadvantage of being the son of an illustrious father. I did not have the disadvantage.
Justice Adi Kasnovi had the disadvantage of being the son of a great civil lawyer. I did not have the disadvantage. I had the advantage of being the first generation lawyer and I had no baggage to carry, nothing to lose. So, this is the attitude that you must adopt. And what provided the impetus for me to do things? Number one, when I entered my senior's office, all senior juniors, that is, other juniors in the office who had already put in 10 years, 15 years, etc. in the office, they discouraged me saying, you don't have a background. You don't have, you are first generation. Why do you come here? Why don't you write some examination and go as a law officer in a bank, law officer in some corporation? Everybody started advising me. Because in this country, one thing that everybody has in abundance to give to others is free advice. We have so much of wisdom in storage, but we are all convinced that this wisdom in storage can be used only by others and not by us. That is why we give it. If you can give it to other people, why don't you implement it in your life? That we can't, because we know it is useless for us. We only give advice to other people. Everybody started telling me, you don't continue in the profession, you have nobody to treat you work, who will give you client, etc. This negativity is what made my resolve more and more. What is all this? How dare these fellows say? Because you must always think, I will never accept defeat. You must always tell yourself, I will never accept defeat. Two things I always tell people. I tell people, you can never make me angry. Because if you make me angry, you have succeeded, I have failed. So even people who try to make me angry, I will crack a joke, make them laugh and say, I have the last laugh. You are defeated now. This is the attitude that you must adopt. Because, see, how do people get on top of you? If they want to irritate you, and they have actually irritated you, they got on top of you. None of us want to accept defeat, correct? But every day we accept defeat by how we react. How we act is not what is important. How we react is what is important in life. Somebody teases you. Somebody tries to make you angry. You get teased, you get humiliated, you get angry, then you are defeated. Never accept defeat. Number one. Number two, I said, who are these people to tell me get out of profession? I am born to achieve. I will achieve. God is there. I had my faith. I had my faith in God. Absolute faith. No doubt. So when you have Swami Vivekananda said, if you have faith in yourself, your faith in God will be true. Otherwise, you can never have faith in God. Without self-confidence, you can never have faith in God. So I said, who are these people to tell me? I will show who I am. I started looking for opportunities. I never rejected a case because the client was not paying well. I never rejected a case because it was beyond my capacity. Whenever some client came to me with a new case on a subject which was not known to me, I will take 2 days, study the subject. Because every client not only brings you money, he also brings you an opportunity to learn. Learning and earning. Actually, first should come learning. After that, you can drop the letter L. If you drop the letter L, what happens? Learning. But what we want to do is, we want learning first. Learning, if necessary, later. That is not great. Hard work. I tell you, as I studied throughout in my mother tongue. First time
I entered college in an English medium school, English medium college. Everything was Greek and Latin. I could not speak one sentence in English. I could not write one sentence in English. When I became a lawyer, I was completely out of, I studied, my law college where I studied was not like this college. The law college in which I studied those days was a college very famous for producing politicians. Therefore, out of 360 days in a year, we worked for about 30 days in the college. Other 330 days, we cared more about the society than about ourselves. So there was no way you can improve your skills or knowledge in the college. Out of college, you are thrown into the water, you have to survive. So you have to. I learned to write a sentence in English without mistakes only after becoming a lawyer. You know that. So it will be a hard journey. But at the end of the day, you score a march over all other people. People who were in my office, seniors who advised me to go into the profession, they stayed in the same place where they were when I became a judge of the High Court, when I became a Chief Justice of High Court, when I became a Chief Judge of the Supreme Court, when I became somebody, they continue to be nobody. Grit, determination, and hard work. Nothing comes without hard work. Nothing comes. You learn to do a lot of sacrifice. So even now, on a topic which is so familiar to me, for which I don't have to prepare, when I come here, yesterday night I prepared. My wife asked me, you have been talking about, no. Somebody may ask some questions. I can't make a fool of myself. I always tell people, if you go to the mic and speak, mouth is the gateway through which people can find out whether your top floor is empty or not. So long as you don't speak, nobody can find out whether you are a knowledgeable man or not. The moment you start speaking, people will find out. So if you are a speaker, you must be always on your toes. You must always read. You must always prepare. That makes you completely different from other people. You can score a march over people who I scored a march over people, my seniors, who were the children of my seniors. That is possible only with grit, determination, hard work, faith in yourself and faith in God.
Truly inspired and thankful to you, sir, for taking out your time in your busy schedule and coming down to Mysuru and broadening our mind, not just about law, but to approach law, approach life in general. Thank you so much, sir. We're truly grateful.
Thank you. Thank you.
Good afternoon, one and all. I'm Antrich, and on behalf of the NEETI Forum, I deem it a privilege to extend our sincere gratitude to Hon'ble Mr. Justice V. Ramasubramanian for making time to interact with us. Your Lordship's thoughts and perspectives have truly enriched and inspired us all. I would like to express our heartfelt appreciation to our faculty coordinators, Mr. Pranav K. Nair, Mr. B.S. Sawan, Mr. Ashish Chakraborty, and Mr. Joseph Thomas for their guidance and support throughout in making this a success. A special thank you to Jani Suresh and Abhijit Kambinia, members of the NEETI Forum, for hosting this engaging interview. The dedication of the student coordinators of the NEETI Forum, Shashwati, Ananya, Kashi, and Mahesh, are highly appreciated, which have ensured the smooth organization of today's event. I would like to thank our wonderful audience for their participation, which has added essence to this session. So with that, we come to the end of today's program. I request everyone to remain seated while we see off His Lordship and the other distinguished guests. Thank you.